We'd like to introduce to you Cindy Stamer. Cindy is an executive director, or I'm sorry, the managing shareholder of Cynthia Stamer PC. And she has a very, very extensive background in terms of this topic. In fact, when I asked her to give us a shortened version of her bio, here's what I got. So she has a very, very strong background on this topic, and we're excited to have her here with us. Let me just give you kind of a little, a shortened version of her background. And it's like this: fresh back from her third year leading the ABA JCEB annual agency meeting with the Department of Health and Human Services, Office of Civil Rights, attorney, author, and health industry leader Cindy Stamer has advised healthcare providers, health plans, health and other technology, and other clients about privacy and data security, investigations and enforcement, and other compliance, public policy, regulatory, staffing, and other operations and risk management concerns for more than 25 years. And I asked her to kind of summarize that even more. She said, basically just say I'm close and personal with OCR. So with that in mind, let me welcome Cindy Stamer to the podium. And
the poor guys here have to roll with the punches because I had to see what OCR was going to say to talk about what we're going to talk about. What we're really going to talk about today is whatever you want to talk about. My world is managing people and process. And in today's world, managing people and process, whether I'm doing it for healthcare providers or someone else, a big part of that is the interface of technology and data. I see a lot of people that were here when I got to come last November, and it's fun to see you back. And you know that I'm pretty interactive. It's a learning process for me. And I'm as good as what you guys share, and I just collect it and pass it on. So if we can, if I can figure this part out, if we can work through it, what I want to talk a little bit about is some things you already know. I'm going to go through some feelings about things that will make the point of the reality of life that you live and that I get to help my clients and work with. And then we're going to come back to some really practical process, because the topic for me is supposed to be sort of putting it all together. And the problem with talking about HIPAA is HIPAA's not the whole story, it's not the beginning, it's not the end. It's part of a continuum of legal, political, operational life. And the balance that you have to walk, that you know because you have to walk it, I'm just the one you call when you're in the do, is that you have to manage all those things in real time. So think about Oklahoma City today, and think about Oklahoma City on 9/11, and think about Oklahoma City when they had the last tornado, all of which I've represented hospital systems. Think about New Orleans, where we had to evac 4,200 kidney transplant patients in 5.5 hours, and systems were down and no hospitals. Think about the earthquakes out here. Those are the big things that gets us. The little things that gets us are the nurses walking down the hall, or somebody leaving a piece of paper, or somebody talking to somebody they think it's their mama, but it's really their stepmama and they're in contentious divorce. And alongside of that, we might be thinking healthcare, but healthcare has other implications. It has trade secrets, it has personal financial information, but it's also the toughest, but it's also the worst written identity statute in the country. It's kind of like healthcare reform. They pieced all the bad things together, and that made us a bad idea, because it just doesn't fit. And none of it fits with what you really have to do. There's almost no one that enacts the laws, much less the regulations, that understands. So last week, or week before last now, I was in Washington. I went to SSIO. SSIO is the people that are putting in place the Affordable Care Act's provisions along with IRS and the Department of Labor. So the people that were in the news, I was on across the table with them for 3.5 hours on Monday the 6th. We talked about how we're going to get that data. Who gets exchange data and who doesn't. And they go, well, we're just going to call them up on the phone because we haven't put together any technology. We're just going to call up the employer and say, well, we've got Raymond Rodriguez, and we want to know if he got offered coverage. And I'm like, well, what are you going to do? Ask them for the Social Security number? You're going to give it? And then you're going to say, oh, well, could you tell me the name of his kids? And could you tell me their Social Security number so we can check them too? And then the next day, I went to head the meetings with the Office of Civil Rights, and I said, holy crap, you need to go retrain CMS. They don't have a clue. It's the same issue. They have the same problems. And what you need to know starts with the who, what, when, where, why, and how of your data. And if you think about it only in this part of it, you really need to think about what is the data and all the different ways the data can be. Because when you think about what is the data, then you think about why you have the data, what the legitimate uses you or and others are allowed to have, what the things you have to do that, what the things you don't, what forms it's in, and you path it in each possible line, then you'll have 80% of what you know that you have to try to accomplish. And before you know that, you know nothing. So too often, somebody calls me up and says, when we have a breach or a problem, somebody just stole this data. Okay, what is that data? What's the most expensive problem on a data breach for most people? They don't know. Providence tells me they spent $7 million figuring out what the data was. So to the question, they don't know. If you're a vendor and you're a storage unit on a cloud and you're hiring from somebody and they don't tell you that that has PHI in it, Office of Civil Rights doesn't care. You're still a subcontractor. They say you're still liable. That's what they told me on the 7th. They don't care if you're an accidental subcontractor, which makes you a business associate. If you are a healthcare provider and some file gets taken and you don't know what's on it, you probably need to assume that everything bad is and deal with it accordingly. There. Just saved you $100,000 of the advice. If you don't know what's on the data, assume that it's everything bad and move on according to that way, because the downside of not doing it is going to be worse than the Oklahoma tornado in terms of your world. But the best thing is know your data. So if you'll think about that, I can tell you why, and we're not going to read all these things. I'm going to have some visuals for you, but it's not just about HIPAA. And in fact, today, HIPAA is really just the starting point, because our statutes, our medical confidentiality requirements, our contracts, our personal financial information requirements, and the public expectation makes these things look like nothing, okay? So think about the folks at the IRS. We still don't know if anybody actually did anything wrong. There's some discussion that perhaps this was all justified. Let's assume it was all justified. Do you think somebody's going to get fired over this? Absolutely. No question. You don't want it to be you. Which also gets to the point that the better your compliance and things up front, the better you can meet the mandate at the end. And today, in your state, my state, even more here than HIPAA, the state-mandated compliance programs and rectification programs make HIPAA look like a cakewalk. So if you don't know what your requirements are and you don't know what your data requirement, and you don't look and actually honestly sit back and say, it's not about HIPAA, it's about data security, process use, access, disclosure, defense, protection. That's your job. And if you want to get some reasons to do it, one is so you can go down in a crash of glory, Mr. CEO. And the other is, while we're doing it, we can also track that data and there's value there. I always like to try to give some business things. So when you think about it, and I say you think about what's the data, knowing what data you have is only part of the question. When you path the system, we're process people, right? We're not like a one-on-one. If you've got to have somebody call me every time you want to decide if you can give a piece of data, you might as well just go ahead and say, forget it now. The world is coming to an end. So what you have to do is come up with grids. Now my grid is, I like to live I'm one of those Rubik's Cube balls, you know, and everything shifts. But the colors have to match up right for the pieces to fit together. And in your virtual world, that's the way it looks like to me. So when I look at that piece of data, I need to know who's protected, whose data, who is the subject. So person claiming or protecting, who's holding and disclosing the information. So who has it, who's asking for it. And you have to know what each of the parties' rights and responsibilities are. Sometimes it's just no. You just say, no, you can't have it. Got to go get a piece of paper from the subject of the information, right? Most of the time, though, it's this game. If you give me the right stuff, I'll say no until you give me the magic password, and then I can go, woohoo, knock yourself out, right? So you have to know who that person is to know what the magic words they have to give you to say, you know, Shazam, come on in. Those 3 grids have to be institutionalized in your system, and optimally not just institutionalized, but automated as to credentialing, documentation, and retention that happened. Because what we just heard from the Office of Civil Rights is if you have a problem, they're going to ask for that. And the great thing about my technology people is that with the things that come through their system, we can actually, through some advanced planning, create systems that both prevent bad things from happening, but also set up evidence to prove the right thing happened, and it happened in the right way. And so when you think about those things and you're designing your system, item 1 is do no wrong. Item 2, be able to prove you did the right thing. Okay? So think about what's in the system, and what I love about technology is it can be the worst enemy because it can show you that something wrong happened. But if you're strategic and you build it right, it can be your best friend, because I can show that we had all these processes in place. And so that's what you do is you start building in these grids, and you can see once you know your great data and you work along those dialogues, you actually get programming code for what we capture. If you actually pull the reports before you go and it catches that data, sometimes we can spend lots of money extracting that data to show in the data logs that the right thing happened, but it costs us a lot of money. If in the process of generating your systems you can produce that, not only will you have a more reliable operating system in terms of not having bad things happen, but you'll also have a system that will be cheaper to defend. And I know it costs you to do that. But when you start figuring that lawyers like me start between $500 and $1,000 an hour, and if the government comes in, they're going to make you do a whole bunch of other stuff, it's a cheaper investment to do it this way. Can you think about ways that you would do that in your environment? My environment does this. It drives people nuts, but we capture all that. So you guys know that these are the rules, but it's good to look at that the privacy rule has the privacy, the security, the privacy rights, a compliance officer and compliance plan, and the breach notification rules, right? Now, we're not going to talk about business associates in great depth because we're going to have a panel about that later. But when you do that, each one of those requirements has a rule and a guideline. And so when we program systems working with people, we actually go and we take those rules, and I actually like, and it's a good time to do it because they're going to re-review it, and remember what she said to you is she wants you to have your gap analysis, your documentation, your assessment done. Well, in my world, we just take those things and we actually take the rule and we take notes. We make all the people that review it sign a little box and we put it in a file. So before somebody like me gets hired by somebody like you, if you want to save $100,000 of legal fees right off the bat, get somebody to bring you in attorney-client privilege so that you're not creating a freely discoverable thing, and start that process on your own and have everybody on your team go through, because it does 2 things. First thing it does is it creates the record. The absence of a record, when I talk to the folks at the Office of Civil Rights, when they say, show me your compliance assessments, your gap analysis, show me. Most people don't have it. They hired an outside consultant. It was done in 1993. It's never been updated. They never actually looked at it. They got a certificate that says we're HIPAA compliant, and they went on. And that doesn't cut it. The second thing it does is really exciting. In the process of reading the rule, you become as knowledgeable as I do. You see, it doesn't take rocket science. If you can program, you're smarter than I am. Forces you to read the rule. When you read the rule, you don't get the Cliff's Notes. You really understand the rule. Suddenly, I get this incredible number of sophisticated questions, even from the lowest level people in the cleaning crew. If they don't like to read it in the way we do it, we actually put it in a Word document and make the letters big and give you space and put one question on each page, just because we find that it's nothing else that meets the adaptive for the persons with disabilities who are dyslexic, right? But what it really does is it takes these silly little rules that they write and takes all the garbage out of them, and it puts it in a form that's not intimidating. And when you put those things one word to a page, people go, I got that. And they read it. And then what funny thing we do is we kind of send those rules out that are important in their pay stubs and their other things. So once you've done the work, it's good. We know the breach notification is really, really critical, and you know all about those rules. the important thing that I want to point out to you about the breach notification, which the new rules cover, is this part right here. Unsecured PHI. What's unsecured PHI? Come on, y'all are experts. What are the two things that makes it unsecured? Not encrypted. Unencrypted in motion, right? What's the other? Right. So there's only two ways that it's secured. It's either encrypted or it's destroyed. Because my hair is really blonde, so I had to shorten it to the stuff I understand. Now, do I understand the actual mechanics that it takes you guys to do this? No. I'm a lawyer. That's like one step above an idiot. What I do know is it has to meet those standards, and if it's not, and it goes outside of the system, we have a problem. Now, two, that's not the only place. Just because it's a breach of unsecured information, if it's a breach of secured information, if somebody uses it wrong, which is a good part of what I've spent the last year with, it's still a breach of the security and the privacy rules. We got that, right? What do you do about that? What happens if you have a vendor or a partner and they misuse secured, protected health information? Do you have a problem? Yeah. So what do? I'm sorry?
We have to terminate the contract and take out.
That's two of the three things. And the response was you have to tell them to correct it or terminate the contract. And what the regulations said before and the regulations say now is if they do not correct it, you have to notify the Office of Civil Rights, which will then means that they have a problem because they have a person who has made an unauthorized use, access, or disclosure of PHI that they were not authorized to have. And even before the business associate rules come into play, people that misappropriate PHI are subject to civil and criminal prosecution under the amendments under high tech, right? So if it's secured, we also have to deal with that. If it's unsecured, we have to follow the breach notification rules. If it's unsecured, as I read the rules, we also have to notify Office of Civil Rights because it doesn't distinguish between secured and unsecured under the HIPAA rules, but you get there from here. So when the unsecured PHI comes into play, you have to notify all of these folks within a timely fashion. One of the things we talk about, right, is the new rules on breaches and business associates and subcontractors and the new data. One of the questions was, what if you're a subcontractor? How far does it go? Well, I just spoke last week at the ABA meeting on international issues, and it goes, if you choose to hire somebody in the Philippines, they're your subcontractor. You are subject to jurisdiction. By the way, if you've got a U.S. healthcare company and you've got people working in Sudan, you're still subject to U.S. law. So even your data over there working with those people are subject to the HIPAA privacy rules. There's no offshoring exemption written into the law as I read it, which is one of the difficulties with using offshore vendors is because as a practical matter, you have jurisdictional questions in terms of you enforce it when there's a breach or other problem, right? So if you're going to use that sort of stuff, you probably not only need to get contractual things, but probably based on the nature of things, you need to do even greater due diligence than you normally do, but we use it. And a lot of people do. So when you do that, it's really everybody. And you have to deal with that no matter whether you're talking about somebody who knows that they're a business associate or not, right? So go back to what we started out talking about before. What data we have, what form do we have, why do we have it, what hat do we have, what hat do that. If you use your controls and you follow the data and apply the analysis at each point that way, and if you teach your people to think that way, both in terms of the systems but in their day-to-day, they'll be better off. I see some people looking, if somebody wants a copy of this, you can have it, I'll email it to you. You can email me. So when we look at these things, remember that there's both rules, and eventually they're all going to pretty much apply. But if you're a covered entity, you're subject to it. If you're a business associate, you're subject to enforcement beginning in September, but you're currently subject to enforcement on the breach notification rules today anyway. And if you're a subcontractor or using subcontractor, you can't feel good about anything, okay? And the real problem is the example of somebody who is on a cloud where they're just wholesale taking all data and it has PHI in it and they don't know. And that's a problem for you, and that's if you're the covered entity, and it's a problem for the person if they're the entity that's receiving it, because the rules apply. But here's the analysis. If you've done the analysis, which the law requires, about what data is it, you're required to know when you're the covered entity or the business associated giving them. So if you fail to notify them of that, you've failed to do your due diligence, right? So you need to be sure that you know your data and where it is, where it's going, and who's going to have it, even on the cloud, even when you send it to your lawyer. And please don't email it to me anymore. I mean, almost every lawsuit I get, probably not a consultant. Oh, we'll just email that to you. We'll just email it to you. Now, I have auto encryption on mine that I can set you up, but nobody on the other end has. They're usually 6, 8 months, a year into the litigation, and then they bring me in, and I go, you just post 4 million billing records. We got to get something. Okay. So when you do the breaches, you need to be sure that you're really working on those issues. But also, the hot and bother of planning about this is that when you have a HIPAA breach, you do need to meet those requirements, but that's just the tip of the iceberg. It is not the only one. Almost always, under your state statutes and your contracts, that's also personal financial information or personal consumer information. And you're going to have data breach notification and rectification requirements under those state laws. And one of the key elements that comes up on breach that I've been dealing with over and over again, beyond the fact that people won't stop using the data or give it back when you're done, is the problem of how you get the notices done, because the state law requirements oftentimes impose obligations on the business associate or somebody else upstream or downstream under an independent statute separate and apart from HIPAA and the business associate contracts. And we've got a great panel planned this afternoon on the BA agreements with some people that actually live your life, you know, in the trenches. And that's a core problem, because when you just do a business associate agreement or a breach notification policy only focusing on one of those rules, you will have a problem. And so we start talking about, well, we don't have an obligation to disclose, but they have a obligation to disclose, but who's at fault here, who's at fault there, who's at fault here? The bottom line is, when a breach happens, we're all running for cover and pointing fingers. And if you don't even know what all the rules are, you're going to screw it up and there'll be more fingers to point. But also, you may find yourself in an unexpected situation where you have a confidentiality agreement in your provisions that has a HIPAA disclosure that says they notify you, and you think you're going to control it, or they think they're going to control it. But then they or you find out that under this state statute, or under a government contract, or under the IRS regulations, because it had Social Security numbers, that there's another responsibility in there. And then everybody's in this dilemma because you can't comply with this rule without violating that one. I make a lot of money when that happens. It's not pleasant for you, and there's no good answer. So the better answer, again, is if you can't tell it, is plan for these things up front. Now, with the risk growing and these other things coming and the IRS and the news today, you can see that the consequences can be big just on the political agenda, right? We know that there have been a few criminal convictions. There's actually more criminal convictions than you realize, because many of the criminal convictions don't come under HIPAA. They come under the federal cybercrime and other laws. But in addition to that, for those of us that work in the healthcare space, there's a whole bunch of additional requirements, like the licensing and the credentialing problems, the whistleblower claims that come out of these because you're firing somebody for taking data home, the trust issues and the like that you have to play with. So when you think about your system, remember that you not only have to be defensive as to the Office of Civil Rights, you have to be defensive as to your management, because sometimes the best thing can happen to you, the worst thing can happen to you is you lose your job or you resign it, truthfully. But you also have to realize that when things go wrong, vendors and employees and other partners in the system get defensive and they start trying to defend themselves. So when you go through the process of investigation, you have to be sure that you don't violate their rights in the investigation, that you're prepared to defend against a whistleblower claim, a discrimination claim, and the like. And so it really makes what you do and how you do it really, really critical. And so if you are not familiar and trained in these areas, you need to be. Because you can't really know what you need to do unless you have that big picture view. And if you think about it, think about this comic. You know, have a nice night, you know, you can rest easy, I'll be guarding the building all night long. That's you guys, right? To a criminal, this place must look like a big old shopping mall. Cubicles are like little stores, each with its own selection of merchandise. If you knew where to look, you could get a picture frame, postage stamps, clocks, and even footwear. Oddly enough, you and the janitor are the only ones here at night, and yet my snack drawer, my data snack drawer, keeps getting empty. It's totally inexplicable. Well, good night. Okay, shall we head over to Shea Dilbert for some data, guys? When I was working with the Secret Service, Mark Lowry was the branch chief, and he talked about it before he came back to Texas to run the Texas operation in the cybercrime unit there. He used to run the HR department at the U.S. Secret Service National Office. He said one day he realized that there was this guy walking around with a box, you know, checking the wires. He realized they'd never credentialed any of their contractors. You guys know this lady? She had a suspected misuse of data. It was a securities SEC violation, but she authorized an electronic investigation without going through the background check requirements of the Fair Credit Reporting Act. It was a legitimate criminal concern, just like you would have if you thought there had been a breach, but she didn't have appropriate consents and disclosures in place. It was not pretty. HP paid big, she paid big. She lost her job. And actually, HP paid $14.5 million for how they investigated. There were criminal charges against the investigators, state charges against several of the people involved. The FTC did a settlement, which was huge, and subcontractor Eye in the Sky paid $650,000, and some of their leadership pled guilty to criminal offenses and got sanctioned. So when you say it works, and when you're going to go look at a problem, you also need to understand how to investigate a problem, and knowing how to image a computer is just the start of the process, because you probably shouldn't even look at the computer unless you've gotten a consent. And you might need to talk to your legal team about that too. My data, my consents are different than off the shelf on the FTC. You know that PDA that they have, my little PDA? You know, I don't have any data on this. I just have pictures. Everything up is on the cloud. I can't even get my own stuff off the cloud because, you know, my geeks won't let me, and I own it. But here's the deal. You fire me, I walk out the door. How do you investigate this on your consents, your background checks? When you do an FTC Fair Credit Reporting Act disclosure form and you got people with mobile devices and data, you generally want it to say I can investigate before, during, and after, and I can investigate anything that you used, including your private data at home. Now that sounds, people call me up and they go, oh, that's terrorist. If some employee walked out of your operations with data on their phone, the government's not going to be laughing that you say, well, gosh, I didn't get a consent, so I can't follow it through. And your ability to follow it through is a problem, right? So when you look at your PDA policies, and then this leads to this, when you tell people, trust me, your data is safe with me, right? You need to be sure that you can really say that, because in the Caremark decision, that was the HIPAA case, right? That was only part of the story. The rest of the story was that their parent company got hit by the FTC, not for HIPAA violations, but for fraud, basically. They said, you said, we care about your privacy and we'll have policies and procedures in place that will protect it, and they didn't. They paid big. Now, when you look about some of these other things, I want to flip through some of these things. How many of y'all have been watching the expansion of the Computer Fraud and Abuse Act and those things as well? That is really, really important. And what's important about all these things that exist here is that they are crimes. How many of y'all have ever heard of the federal sentencing guidelines? You know, that's what the drug people get charged with, right? You know, organized crime. Well, we can be organized crime too. And so those are all felonies and Class A misdemeanors under law. And so with these things going on that you guys know are a big issue, this is hot stuff. You think it wasn't before, wait till you see what Congress gets done after you find out people wiretapped their bathrooms and did all those other things, okay? And when they do those things, there's organizational rules under the federal sentencing guidelines. And it means that if it's like the Enron thing, if something happened on your watch and you didn't have appropriate safeguards, if a business does the problem, then if something happens and it's a crime, and one of their employees or agents does it, then the company's guilty. It's vicarious liability. The question is, what's the sanction? The other thing that many people don't understand is if you're in the management stream and you were responsible for preventing it, or you learned that it happened and you failed to properly address it, you too can be personally liable, criminally. And that's how these executives on these kinds of things get in trouble. And this gets us back to the problem of employees and business associates. I had a great visit last night with one of the people that's probably on the other side. We had a good forensic discussion. I know we worried about hacking and breaches, but what's the number one cause of a breach? It's internal, right? It's vendors and employees, usually disgruntled ones. And so they're key, but they're also really protected on the investigation side, and if you don't do it right, that vicarious liability attaches, okay? So when you deal with them, one of the things you really need to look for is the back door. There's a study that the U.S. Secret Service did, it's probably about 2 years old, that talks about the number one person that causes a breach is you guys, chief security officers. You're it. So those are the problem is it's not the computer, it's not the company. I have never had a client call me up and tell me, how can I break the law and get away with it? Just nobody has ever paid me for that. Maybe I'm naive. I'm not too stupid to understand the question that they ask me. Has your boss ever said, figure out how to break the law? I'll pay you lots of money. If they do, we need to talk, because you probably need a different job, but that's not what it is. So you've got to really look at the data, because the controls are only as good as your people, okay? And so this process of reading the rules, internalizing the rules, scaring the heck of them out of the rules because you have great power but you have great responsibility, they can get it. And when they do that, it's really one in which almost every reason that could ever been a crime is now coming into yours on the traditional things. So people that want to do credit card theft, the Gibson case, right? The first criminal conviction. Those things fall into that. But also, the second category is just people that just don't know better because we have a disrespect for privacy and rules. And so when we're looking at all these things, the government's looking at all of these cases, and they know that that's a problem, and they know that the only people that they're going to really hold accountable is the company that employed them. And when the company holds somebody accountable, then what's going to happen at the IRS? They're going to find the person highest up on the ladder they can get enough satisfaction to fire, and low enough down that they can pass the buck down, because that's what my job is to do when these things happen. And so when you do that, you need to watch those people because they're watching you. And so all those things, if you're going to be putting those safeguards in place and you're watching them, when you put those controls, now think about lockout, tagout, talk about the documentation systems that you put in place so that you can do the accounting for disclosures. Now think about, do you have appropriate consents that says you're signing into the system? When you come into the system, you represent that you're credentialed and qualified, that you'll only use it for this purpose. If you don't, you should. Why? Well, one, it's a very critical part of the corporate compliance mechanism. Two, it helps to promote compliance. And three, if those people go beyond that in the criminal and the cybercrime laws, as well as in these other laws, that means they've affirmatively taken an action that they've represented to you, that they know the rules and that they represent they won't do it. That makes it not your act. It makes it outside the course and scope. It's an unauthorized act that they've knowingly and willfully done. Congratulations. If you put a little data and a couple check the box, you've just moved me 50% away from it being your fault to being their fault. and walking clear. It's the lipstick on the program. It's the difference between getting your nails done when you go to the pageant or not. For you guys, it's a difference between taking a bath before you go on a date. Little bit of gloss goes a long way. One, it prevents problems. Second, it prevents you being in the HP. And three, it takes you from HP to making you guys being the criminal, and I'm just a good guy that was a victim. So here's your employee locator device. Sensors in the buildings will be able to track you at all time. We know many times you use the restroom and how long. It's a dog collar, the final humiliation. Once you get used to working in cubicles like gerbils, we knew anything was possible. My conformance rationalization mechanisms are kicking in. It's not so bad. A collar is simply an efficient design. Everybody's doing it. It's powered by the 6-foot-long extension cord. Now mine is wireless, by the way. You're looking at all these things. If you want to see the comics, listening in, add the wiretap laws, right? Physical supervision, where, why? Guess where you guys are? First adopters on the personal things. Datas are big, and you too can go to jail. But when you're doing it, they're also going to sue you. And so even if you're right, when they sue you for wrongful discharge, they'll walk clear probably with $500,000 plus attorney's fees, unless you do it right by getting the disclosures and the things in place. And oh, by the way, if they're a criminal and they come to somebody like me, the first thing we do is we take them to the feds. We want to be in the door first, right? So when you do these things, you need to be aware that there are people that are deliberately or let's say with careless negligence doing these things, they're planning for a defensive strategy. So we can talk a little bit and still go to lunch and be at the first of the line. First thing I want to talk to you about is attorney-client privilege. Has anybody ever explained what attorney-client privilege is and how you use it to y'all? I know it sounds like it's just effective lawyer marketing. And it is, but we wrote the rules. Okay. Attorney-client privilege and work product. Two very important rules of evidence. There is actually a third one that I want to talk to you about as well called the business record rule. These are all very powerful tools. I teach a course for CEOs about 10 things every business person should know about the law. These are 3 of the 10. So double bang. First of all, attorney-client privilege is a protection of communications. It involves communications between an attorney and the client. If you're in a corporate sense, it's designated people within the client. It also sometimes can include consultants, but you have to take special procedures to bring the consultant in the scope of attorney-client privilege. It's a communication that's a confidential communication, so if you let somebody that's not in the scope of privilege participate, like a well-meaning consultant, and you don't follow the procedures, everything you say can and will be used against you. And since those conversations are usually pretty sensitive, you want to be careful. The second thing is there are limits on these communications. So let's say that you had a major data breach by the CEO of the company, decided he was mad at his wife, took all the healthcare information, decided to go ahead and crucify her by posting it up on the 405 on a billboard. I know that sounds odd, but I've had that happen. And now you want to know, what do you need to do? And I'm like, under the law, we have to conduct an investigation. We have the federal sentencing guidelines, so we're responsible. There was a crime, right? If it's a criminal act, I can advise you about cleaning it up. I can advise you on the front end with the scope of attorney-client privilege that you need to follow the law, but if you tell me I'm going to break the law and I'm going to engage in a criminal act and I'm going to cover this up, I have to say, I'm going to resign from this representation because I can't advise or assist you in the commission of a criminal act. And because that's the case, you also need to know that there is no attorney-client privilege should I participate. So if you're going to pursue this course of action, I'm sure you're going to be totally comfortable with me resigning. Because you're not going to want to talk to me about this because I'll have to testify against you to defend myself. Okay? So if it's a criminal act, there's no privilege. And we've had in the healthcare fraud area a couple of law firms. Shikardi barely escaped liability because they were accused of that in the billing area. So communication between an attorney and their client, limited to participants that are only in the team, and that's kept confidential. So we go in the corner and we have a confidential discussion. Don't tell anybody. Or maybe we do it on email, preferably encrypted. And then you broadcast it to everybody on the team. Hello? Privilege gone. So no distribution lists on attorney-client privilege communications. Okay? Because what you say can and will be used against you if you lose privilege. Work product is basically work that's done in preparation of the defense or risk management. It's not acts outside of it, so you can't cover up the fact that you dumped waste in the harbor. But you can use the work product of the investigation. Same rule applies, has to be confidential. Business records. You know, I keep harping about how I love your systems because it makes records. The old-fashioned rule we used to tell you is, if you're going to do something like, how do I know I did this at this time? Well, I chart. I'm the daughter of a nurse, so I tell people I chart. When you call, I chart on the phone. I chart on my BlackBerry. I chart on my, my Microsoft phone. I chart. Your systems chart. The system makes a record. And the rule of business records evidence is that if you always do something, the fact that it happened and that it's there. So if the system always puts code number 4007 when this happens, and code 4007 is there, then there's a evidentiary presumption that whatever always pairs with that is what happened, and that is evidence that has to be rebutted. If the system always shows when somebody tries to access something, and there's no record of anybody accessing it. Citibank drives me nuts on this. I didn't get anything from your credit card. We never heard from them, right? That's a rebuttable presumption that Macy's didn't call them, or that there was a defect in Macy's system. Now, in the fullness of your existential being, don't you feel powerful? Because you can set up your system to track evidence, not just the ones that the evidence the government wants you to convict you with, the required disclosures, but the evidence that will help you defend and mitigate your damages. Hence, my comment, check the box. I'm not supposed to do this. I certify that I'm only entering this the way. If you check this box, we've done our due diligence. Anybody that checked it, we can show we didn't go back and check it after the fact because the system would show that. Your systems, what you do, what you're capable of doing, should your company understand it, is so powerful that if you understand that, now you understand why I want to go back to the grid, and I want to get everything I know into you guys. Because all I need to do is give you the code. All the statute and the regulations is the code. I can't guarantee some nurse or some social worker's not going to go half-cocked on a piece of paper or just, stand on the freeway and sing the privacy of somebody that just irritate them. I can't do that. But that's not a mass problem. And we can deal with those, and it sure shrinks down what I need to worry about. But if I can get you guys to operationalize the system and OCR comes in and I can say, give me a report. When I can do that. We're in and out of there for under $15,000, and that's usually well below even a risk hit. It doesn't even count against you on your liability policy. So when we talk about these things, attorney-client privilege, work product, business records makes you one of the most important people in your company. And you can use that not just for privacy and data security. So the rest of the stuff here, you all know this. What is this? This is the outline of the gap analysis, right? You guys could do the gap analysis rap with me, right? We know we need to do this. But one of the things she said is oversee compliance. People did it back in the dark ages, but they haven't done it since. Every time there's a problem or a red flag or whatever, you got to do a risk analysis with documentation. Every time there's a breach, you got to do a little mini investigation. You start at that point of the rule and you document it. I prefer that you put privileged and confidential by review by counsel and maybe call them for 5 seconds and get them in so you can look at it. But if you don't think so, you're going to still disclose it eventually. If you don't do the investigation, I can tell you it doesn't matter whether you call me or not. If somebody complains, you're going to have a problem. Consistently enforce standards through appropriate mechanisms. When she was talking today about there's all sorts of different ways and we can't tell if you disciplined or if you looked into it, it does not need to be a dissertation. Gather up your evidence, put your notes in, take a copy of the rule, circle the rule, put a thing to the side, write it in the margin, stick it in the file, scan it, send a note up to discipline about what and why. If you're worried about it, you might want to call counsel for 5 minutes, but if you've already done that, it's not going to cost you for so much. And then this is the discipline. This is the reason. It goes in the HR file, corrective action, tag it for follow-up. People that violate rules once oftentimes need retraining or oversight. So just because you counsel them, don't assume it won't happen again. When you do these things, the problem with this is not that you don't know the list. The problem is management's hard work, and you have to do it every day. Now, in my world, I got so much better at my job when I became a mom. Why? Because now I see the 4-year-old and all these people, and I realize that we're all just inside still the 4-year-olds. The things we didn't do well when we were 4 were the things we still struggle with today. It's a wonderful tapestry, but that's why we all have to coach ourselves to better improvement. And we got to monitor for the weaknesses and the strengths and use that team to get it right. And so people will make the same mistakes over and over again because it's habit, and they're still that 4-year-old, and their mama's not coaches them anymore. And so anymore in our workplace, we try to set it up so we take away the keys to the jelly bean jar, move away from the data in the places where we don't want to have them, control the data so they have to get permission. And then if we give them permission, they use it wrong, we bop them. And we keep retraining them. When you do that, it's a really revolutionary thought, but people have an outcome. Our outcome is we want people to comply with the rules and not take our data and misuse it. That's our outcome, okay? That's like saying I'd like to have a perfectly tasting apple pie. What I have found working in management is that people don't know how to manage. So when you think about what it is you want your people to do, what you don't want them to do, where they have the opportunities to have misjudgment and abuses, where they have the opportunity to build the system, make it easy to do the right thing, then your things will become easier. And it's in all the transactions. Your people are not just your employees. They're not just your business associates. They're everybody in the chain. Your customers, your patients, your vendors, their extended family. That's all important. So what you have to do, in other words, is now that you're armed with the 3 most important rules that any lawyer knows, is you need to plan for that. Don't overpromise privacy, safe what you have, manage the risk, have good policies that you show that you use them, deal with these kinds of risks by teaching people not to do it right, establish an expectation, don't treat them like they're too stupid to do it, but don't give them the ability to do dumb things any more than you have to. Credentialing and watching them and holding them accountable. Make sure that somebody like you, who's fully informed as to both the technical rules of privacy and data security, but the other rules, is there to monitor. Credential those people. Remember I told you, the CSO? We have rules for credentialing, and we re-credential, and we hire outside vendors to look at it. Those security, those subcontractors, really frankly, that's what the audit, when they told me up at the Office of Civil Rights, is they know there's just a cesspool in the downstream business associates and subcontractors. And just like that, I know it's an amazing concept, I write beautiful contracts. And I'm telling you, my business associate contracts aren't just 10 provisions. But just because you put it in writing, in fact, sometimes when somebody agrees too readily, it makes me more nervous because they don't plan to comply. That's why they agree. And in this case where it says some liabilities can't be delegated, they aren't going to let you delegate going to prison or having a sanction. If you're the covered entity or you're the business entity on a subcontractor, you are liable. So you need to really monitor for suspicious behavior. And think about it more like a red flag rule, which the security rules also have, which is not just when there's an actual known breach, but also signs of a breach. And make sure you get the right disclaimers in place, because that's where we're having huge liability come in, is because we're hogtied between the ability to get the consents to do the investigations, because back when you hired people or subsequently leading up to it, you haven't gotten the authorizations into the business associate agreements, into the employment agreements, into the policies and the handbooks. And so we're trying to figure out how we investigate without going to the feds, because we're not sure if we have a problem, but we can't really investigate because we can't do the investigation because we'll commit a felony if we do. Use your buttons to restrict access. Our model today is you can't have it unless you're credentialed. This is not Jerry Steinfeld, and it's not the water cooler. Make them prove that they can get in unless there's a health and safety risk. Time is on your side. No matter how mad they are, it's better than giving, because once the data's out, data, air, and water, you can't get them back in, they flow. Collect only what you have in a legal means, and if you do this through this process, you'll be self-proving that you've gone through a legal means. Collect only what you need, and only through the established protocols. No hacking, no backwards, no covert operations. Know when people are trying to work around the system that that's a red flag. Might be an appropriate outcome, but they got to do it the right way. Remember that under the privacy laws, under state law, the actual damages really come for things like negligent infliction, intentional infliction of emotional distress, invasion of privacy. And California has more common law liability than anywhere else. And so that's where the multi-million-dollar damages come. So teach your people to zip their lips and lock their data files, because it's for their protection and yours. And you can teach them things. This is a little bit politically incorrect, but as you can tell, I love comics. Dogbert says, follow these steps to get rid of callers who want information. No matter what they ask, just give them the information you have right in front of you. I got some good information on the days of the week. If the caller protests, make them restate the question in as many forms possible. How would the Hopi Indians phrase that? Act like the caller's question makes no sense whatsoever. Are you talking pig Latin? What do all those words mean? That's like talking to a lawyer. Pause 20 seconds. Pretend you've forgotten the entire conversation. Hello? Have you been helped? Now put the caller on hold and disconnect after 10 minutes. Oops! If they call back, scan the obituaries and refer the caller to the recently deceased. Boy, I hope nothing happened to old Ben, because he's the only one that has an answer to your question. And if the pest calls you again, slip into a foreign accent and start over at step 1. See, they may not all be in the Philippines. Don't overestimate conditional privilege. That means you think you might have the ability to do it. If there's a health and safety risk, if there's a reason to do it because it's a reference, make sure you're in all 4 corners of the box. Anytime you're going on anything that I think it, you should document it. Keep on doing it. Follow the protocols. Only do it for the reasons you say you're doing it. No misrepresentations. Be reasonable. Use maintenance procedures. Keep training, but don't just train the rules, train what we're talking about here. The privacy matters. And then when you've done all that with your self-replicating system, you conduct an investigation. You also have a plan in place for when an investigation comes on who can be the response person, how you're going to disclose if there's warrants and seizures, etc. And you're going to have good documentation because you're going to already be systematized to do that. What's the story? Document, 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 and have a disaster recovery plan. And what I'm telling you is your system is one of the key elements of the disaster recovery plan. So if you have the ability to track the data, check all those boxes, because we're going to need it someday. Know your data, know how you can track your data, know how you control your data. And the fancy word in my world that I learned about 20 years is directory access, and you'll be fine. Thanks for letting me come. If you have any questions.